Without students to teach, clients to work with, library patrons to advise and guide, the busy world of intellectual property had a very productive 2 years in 2021 and 2022. As a high school teacher for 37 years, an adjunct faculty member at George Mason University for 32 years, and an intellectual property specialist for just as long as both of those, I'm with you today to share with you all of the intellectual property events of 2022. Today we'll be looking at the fact that the Library of Congress has finally started to modernize its extremely clunky and antiquated system of copyright reference, that there may actually get to be a small claims court, since most copyright infringements do not happen at the Taylor Swift level, but mostly in our communities for small stakes, that libraries and ebook retailers continue to fight it out for how many subscriptions a library can have, and I'll give you at the very end a quick list of issues to watch in this coming year. While it's working on modernizing that website, the Library of Congress also comes up every 3 years for review, and the librarian makes rulings that affect all of us in instruction. In spite of its name, the Copyright Modernization Committee is actually modernizing the way that copyright's made accessible to the public. It isn't actually changing the law. But last July, they reported out at last, after 2 years of work, that they were going to come up with a virtual card catalog, a data management plan. Nobody quite knows what that means yet. And important to us, an easier way to be able to record your copyrights, and an easier way to register and make it public so that others can find whether material is copyrighted or not. When it deployed at the end of the summer last year, it reminded me rather of Star Wars in the design, but you can see under resources that it in fact has a very short and sweet clickable table of contents, and as intended to explain to the public what is happening while they're working on their copyright records. Highlights of this year's review include being able to jailbreak streaming devices, which have become so important in online instruction, so that they are no longer tied to any one content purveyor and can use content from multiple sources, which you can see is extremely valuable for teachers at any level. Also, these days, staff can now be directed to reformat materials to make them accessible. Previously, it had to be librarians or faculty, which usually meant special education faculty, but now it can be anyone. So that lifts the burden somewhat of that very time-consuming effort. Same thing with copying video excerpts if they are needed for online learning, and particularly for MOOCs, then it is now legal to copy them specifically for instructional purposes. Format shifting has been around for a number of years, in that if something is only available on an old video, or it's available only in text, it can be shifted so that you can go text to speech, speech to text, whatever. This particularly applies to special ed accommodations, is needed for a user to be able to access the material in a format that they can use. When the Copyright Alternative Small Claims Enforcement Act, the CASE Act, was enacted in 2019, it largely got derailed by the pandemic until quite recently, but it had a solid idea, which is that schools especially teachers, even more than students, have a tendency to reuse copyrighted material that they're not supposed to. Should there be an issue about that, there will be a small claims court where it's possible to settle this at a level that will not bankrupt everyone. The idea is for the matter to be able to be handled by agreement without a trial if at all possible, or with just a hearing, so that it favors the authors, so creators of artwork or written works or dances or band performances. They can protest if they feel that their material has been misused, and counter notices are possible so that the supposed violator can defend themselves. The idea is to make it possible for literally almost anyone to be active in intellectual property if they feel the need. And also, if someone is guilty, they don't have to defend themselves if they feel there is no defense. They can simply pay the judgment. Filing a claim only costs $100. At present, it's $150,000 possible damages per incident, and the total damages, adding on those 150s, can go on forever. The idea here is to cap it so that it's actually payable, so the penalties will actually work, so that now it's a maximum of $15,000 per incident, which sounds a lot until you consider that it was 150, and that the damages, total damages, will be capped at $30,000. It's also emotionally satisfying to know that this small claims court can, in fact, completely dismiss copyright trolls who go around threatening to sue people or just suing them with baseless suits over and over and over again, either for the attention or to get them to settle, so that over time they accumulate a good deal of money simply by being a troll. So if they are frequent flyers, it is now possible to prohibit their filing any claim of any kind for up to a year after they've been judged to be frequent offenders. As I'm sure you all are more than aware, one of the ongoing library struggles is with being able to get multiple copies of very popular titles, which now is not happening, and then having to put eager patrons on long waiting lists for new bestsellers. This, of course, led directly to pirates attempting to download and steal ebooks in quantity. So a big-time website, a big-time paper publishing house, and a big-time author teamed up together to combat this kind of piracy in the ebook realm, and they actually have been given $7.8 million judgments so far and plan to continue this crusade. But of course, the basic legal problem of libraries not being able to get very many copies of popular and in-demand titles seemed as though it were going to resolve itself. Last summer, both New York and Maryland instituted programs which simply said that vendors could not prohibit libraries from buying as many licenses as they wanted, on the grounds that libraries should have reasonable access to digital books, as long as they pay the market price like anybody else. Unfortunately, the Association of American Publishers just a few weeks ago sued the state of Maryland over this exact issue, and on the grounds that the federal copyright law then interferes with publishers' rights to distribute their works as they wish. Therefore, large-term access is currently denied. I'm sure this case is on its way to the Supreme Court, so keep an eye out for it. One of the unexpected side effects of the pandemic was that researchers of all ages and all skill levels were stuck at home without access to the university libraries in particular, who can pay the huge fees for the databases that contain scientific articles. Therefore, Sci-Hub, the oldest, the largest, the most successful of all the research pirate sites, has absolutely had it. Now, should your library or school get a takedown notice on the basis that students or other users have been pirating things, here's what you need to do. Immediately disable their access. Find the computer that they're on, get your IT people on this. Notify the user who posted it that they are illegal and in violation of all the policies that they've ever signed off on. Make sure that they have a chance to defend themselves, just file a counter notice, but make sure you have a registered agent who will represent the school system should there be a hearing. If you do not have such a person, the link on this slide will show you how to get one. While the previous issues have been maturing for up to 2 years, there are a few things that are just starting to happen in 2022 that we don't yet know what's going to happen exactly, so keep your eye on these. First of all, it is now possible to buy a whole suite of tools which will allow piracy of almost any kind of intellectual property whatsoever that's available online. It's known as PAAS, Piracy as a Service, so that it becomes possible to become a commercially successful intellectual property pilot. A ruling has just come out that it is not possible to copyright art created by an artificial intelligence. The gentleman in the lower left, using his software, the Creativity Machine, tried to copyright this image and was denied in February. Now, the grounds were that a copyrighted work must be created by a human being. If you think about how that extends over to video games, there are beginning to be graphic novels and cartoons that are entirely created by AI. Already a number of instruction manuals and reference materials are being AI created. This is something that could grow and grow and grow and become a major area, possibly even short story or novel writing, for instance, and an item of continued litigation. So keep your eye on this one. There's been a years-long struggle over the interpretation of Section 230 of the U.S. Communications Decency Act, because that's the one that makes web hosts like, say, YouTube or Facebook responsible to police their sites for copyright infringers. Most recently, it was in October, but it didn't go into effect until January 1st of 2022. This particular judge said that, nope, it's not their problem. And if it's not their problem, who is going to patrol those enormous sites? The judge seemed to be dancing around the question of liability or obligation. And the way that he explained it was that if you don't make it worse, if you just infringe, but you don't make it worse, well, then that's fine. On a much more positive and intellectually curious note, the ALA has an initiative called the Library of the Future, trying to envision what libraries will be in 20, 50, 100 years. And one of the things that they're trying out is booksgosocial.com, where it's possible to get materials entirely using NFTs without a library card. And if indeed, especially rare books or other types of materials like, say, music that a library would hold can be identified by NFTs, then you really wouldn't have to worry about whether they were stolen, pirated, or what, because you would know who they belong to. ALA is exploring this. It's a brand new initiative. So look in the next few years to see what they've figured out about it. They are doing what might be described as a pilot study. Starting last June, copies became available this January. They're trying 14 different titles. The idea is also to favor authors such that they do in fact get their fair payment, and in fact would get much more than they usually would, 10% of the price, which under current royalties is not happening. And you can either use PayPal or Stripe to buy one of those 100 copies of the 14 titles. And it also comes with a lot of enrichment materials as well. So we'll see if those sell, how well they do, and whether authors do in fact benefit. I'm sure you're aware that the Marvel Cinematic Universe is currently under threat or discussion. This will be the ongoing big discussion of the next year, year and a half, while they work out whether Disney can continue to control the MCU, which they bought, whether in fact the artists who designed Hawkeye, Spider-Man, Iron Man were working for hire, in which case what they did belongs to the company, now Disney, or whether as the authors, and in many cases their heirs, because they designed these characters so long ago, and many of them are not still living, were acting independently and then are therefore entitled to their own copyright. If Disney wins this war, then the current law will say that Disney is entitled to maintain copyright up to 95 years after the original publication, or up to 120 years after creation by the corporate author. Now, that distance of 25 years is what's currently being fought over. Do the authors have control? Does Disney have control? Stay tuned. This will be in the courts for sure. So as you can see, the intellectual property universe has been full of color and drama and explosions. And there will be lots to watch for that will affect instruction at all levels, and also the maintenance of libraries and general public education for the next years and years to come. If you have anything you'd like to discuss further about this, please contact me at the email address on the screen, and thank you for listening.